Okay. Good afternoon, and we've got a remarkably thematic last set here. So it is my privilege to introduce the next speaker. Christine Bateup is a co-founder of Frere Jones Type, and she also holds, if I had it right, 4 law degrees. 4 degrees, 3 of which are law. Okay. As you can imagine, she has been putting a whole lot of thought into the legal aspects of fonts. And what is particularly hot in that area, of course, right now is artificial intelligence and how it interacts with intellectual property rights. So please, I'm very much looking forward to this.
Hi, everybody. I guess it's probably clear by now that I'm not a type designer. I'm not a designer at all. I am a lawyer. I'm a lawyer both here in Australia, where I'm from originally, and also in the United States. So today I'm speaking specifically about US law, but I am familiar with a few legal systems. I need to begin just by stating that because I am a lawyer, the information in this presentation is general in nature. I'm not here providing legal advice to anybody. And I also want to begin by acknowledging the traditional custodians of the land on which we stand, the Turrbal and Jagera peoples, and pay my respects to their elders past and present. So, yeah, my talk does fit very nicely after Mary's, who introduced us to some of the possibilities of AI in type design at the moment. And I know regardless of your views about this in our field, my goal here today is to help you gain a better understanding of the copyright law implications of generative AI, specifically with respect to US law, so you can feel more confident navigating these waters if and when they do begin to impact your business. But first, why should you care about US copyright law in particular? You might be a font designer from Australia or from India, say. What does US copyright law have to do with you or your business? So there are a few reasons it's good to have a basic understanding. Even if your agreements state that they're governed by non-US law, you might have a US client who wants US law to govern your agreement. You might discover unlicensed uses of your fonts by a US company, or your US company using one of your fonts beyond the terms of your license. Or perhaps a US tech company might be using one of your fonts to train its generative AI model. Now, you may be aware there's no global copyright law. There's just a patchwork of national laws and international treaties. The primary treaty you may have heard of is commonly referred to as the Berne Convention, and most countries in the world are contracting parties. So if your country is a party to the Berne Convention, in order to sue to enforce your copyright in the United States, you need to sue in US court and apply US copyright laws to the dispute. I should also say, whatever country you're in, you should gain an understanding of how copyright law functions with respect to AI in that country. There's a wide variance, and again, this is just US specific. So first, I'm going to look at copyright and generative AI inputs. And the key question here is, can copyrighted material be used to train generative AI models? So if you've been following the news with respect to copyright and generative AI, this is probably the issue you've read the most about. Here on the screen, this is just an article that was in the New York Times a couple weeks ago, which looks at these very issues. And as you are all probably aware, most generative AI systems are trained on huge amounts of content, be it text, code, or imagery. So Stability AI, for instance, reportedly scraped and copied over 5 billion images from across the web to train Stable Diffusion. There are a range of lawsuits happening right now in the United States. These are brought by artists, writers, media organizations, challenging the use of their copyrighted works to train generative AI models. They want AI companies to stop using their works without authorization or compensation, and they're concerned about the flooding of the market with mediocre content. The primary claims in these cases are claims of copyright infringement based on the use of copyrighted works to train the models without those works having been licensed. And with limited exceptions in these cases, the defendants have not sought to dismiss the copyright infringement claims, but they want to proceed, and they've signaled they're defending their claims based on a fair use defense, which I'm going to get into. And they want a factual record to be presented. Basically, they want rulings put in place that are going to allow them to continue what they've been doing. So, given these cases come down to fair use, what does this concept mean? Fair use is a uniquely American concept, though it does have similarities to the concept of fair dealing in the United Kingdom and in Australia. So in a nutshell, as you may know, there are two ways you can use someone's copyrighted works. First, you can obtain a license, or, even without permission, the use might be said to constitute fair use, which can be raised as a defense to a claim of copyright infringement. So in effect, fair use is a justification for copying a copyrighted work without the creator's permission. Fair use is a very fact-dependent test, and courts undertake a balancing exercise looking at the four elements on the screen. In reality and in practice, it's really the first and the fourth factors that have the most prominence, and that's also true with respect to generative AI. So in a nutshell, the first factor looks at whether the use adds something new with a further purpose or character, so it changes the nature of the original work in some way, rather than just supplanting the original. In that sense, is it transformative? And the last factor looks at whether the use threatens the livelihood of the original creator by competing in the same market. So at first glance, it might be hard to understand how the use of copyrighted material without permission to train generative AI models could be said to be fair use. The models are often used to create substantially similar works to the material on which they're trained. And I have an example on the screen from one of the lawsuits. The work on the left is an original piece of artwork by the artist Kelly McKernan, and the work on the right is an output from Midjourney from the prompt Kelly McKernan teacher. So it's hard to see how this is transformative. And surely the use of copyrighted material to train these models will ultimately threaten the market for creatives in the fields in question. The tech companies, however, have a bunch of arguments about why they think that they can use these works without having licensing in place. So for example, Meta has argued it would cause chaos to now require them to license copyrighted works because they've been using these works without a license. Plus, any single work is so insignificant that the copyright holders wouldn't get much money anyway. It's also been said that requiring consent or licensing from copyright holders would chill AI innovation. And if the US ended up requiring this, developers would just go offshore and do this elsewhere. It's also been said it would be impossible for them to create useful AI models without using copyrighted materials this way. And finally, one of my favorites, it's been said that investors have spent billions and billions of dollars, so upending their expectations now would harm future investment and US national security. So these are all arguments that have been made to the Copyright Office recently. But turning specifically to the tech companies' fair use arguments, what they say is that training their models on copyrighted materials is fair use because the purpose of the training isn't to create infringing output, but it's to teach the models how language and visual images work, and that is a transformative use. They also say that the models themselves, not the output now, the models don't compete with the market for original creative works, so fair use balances in their favor. But what about the infringing outputs? Well, about that, they say, well, the models predominantly create non-infringing outputs, so they qualify for fair use, even if the models can be manipulated in rare instances to create infringing output. In addition, if you look at the terms of service of these models, and I suggest you do if you use them, they don't allow generally for the creation of infringing outputs. So they put the burden on you as the user not to do that, basically saying if somebody's using this to create infringing works, it's not our problem. Ultimately, these cases boil down to the question of whether it should be a copyright owner's burden to subsidize the development of generative AI by billion-dollar tech companies, and whether those companies should be able to shift the burden of infringement to users of their models rather than themselves. So these cases are all pretty early in the process in the United States. The first one has a trial date set for later this year. I think most of the others would be much later. So watch this space as these cases continue. The next issue I'm going to look at, and the predominant issue, concerns copyright and generative AI outputs. And the key question here is, are works that consist of or incorporate AI-generated material copyrightable? And the answer to this question centers on whether AI-generated works are works of human authorship, as this term is understood in US law. So what is an author? AI systems introduce challenging variations to the question of what is an author under US copyright law. Does the user of a generative AI program become an author of content that they create using that program? Might the creator of the program itself become the author of works that that program generates, even if they can't anticipate the content of the works? Or might the generative AI program itself be considered the author in some circumstances? So here I'm going to focus on the first question regarding users and whether they can become authors of content that they create using such programs. And why is this relevant to you as font designers? Well, first and most directly, if you do end up using any AI tools as part of your font development process, these considerations regarding copyrightability will have to be borne in mind. And secondly, and perhaps unexpectedly, I think that focusing on the meaning of human authorship in this context has implications for the question of the copyrightability of font software in the United States, which I'll touch on near the end. First, a quick note about copyright registrations in the US Copyright Office. So copyright attaches immediately upon the creation of original works of authorship, provided they meet certain requirements. So why register your copyright? You can, but you don't have to register your work. But having a certificate of registration comes with certain benefits. If you're a US citizen, you need to register your copyright to sue for copyright infringement. Also, for everybody, it enables you to claim statutory damages and attorney's fees, which is a lot higher than what you might otherwise be eligible for. Courts also provide some deference to Copyright Office decisions on registration decisions, but ultimately, questions of copyrightability are for the courts to determine. So the human authorship requirement comes from the US Constitution and the Copyright Act in the United States. You'll see the Copyright Act states that copyright subsists in original works of authorship fixed in any tangible medium of expression. So there's a few ideas here. The first is that works must be original, which is a fairly low bar to meet. Second, ideas are not copyrightable. They have to be expressed in a tangible medium of expression. And there's the concept of the author. So most basically, an author must be a human, not an animal, a deity, or a machine. There are cases that have looked at each of those questions, which I wanted to show you, but did not have enough time. But how much human involvement is necessary for a person to be considered an author? So generative AI isn't the first time courts have had to consider the question of the impact of new technologies on the concept of authorship. When cameras were first invented, there was a raging debate about whether photographers could claim copyright over photographs. And the first case to consider this in the United States was this decision, Burrow-Giles and Cerrone from 1884. Burrow-Giles marketed unauthorized copies of Napoleon Cerrone's photograph of Oscar Wilde, which you can see on the screen. Burrow-Giles argued that photography was merely a mechanical process, so that Cerrone wasn't an author for copyright purposes. The Supreme Court rejected this argument and found that Cerrone was an author because his photograph represented the original conceptions of an author. So a camera might generate a mechanical reproduction of a scene, but it only does so after a photographer develops an original mental conception, which they give visible form through all of their decisions in forming the photograph. Here, Cerrone conceived of the scene, which he gave visible form as a result of all of the choices that he made, imposing Oscar Wilde, selecting and arranging the light, the background, and other aspects of the scene. It's also worth noting that Cerrone didn't operate the camera himself. His assistant did. He just set the scene to be photographed. Even so, he was considered the author, as the assistant was conceived of in a similar way to the camera. They were both seen to be mere tools. Neither usurped Cerrone's original mental conception. The court also referred to an English decision in Nottage v. Jackson, which considered authorship and the copyrightability of photographs. And they said that the author is the person who superintended the arrangement or who was the inventive or mastermind who creates or gives effect to the idea. So since Cerrone, there are certain situations in which copyright law is content to ignore the generative role of the creative tool that a creator is using, and to instead recognize the claims of the human masterminds who stand behind the tools. So the key principle here is that the author can outsource certain processes of execution of their vision to a machine or another human, and they can remain the author, provided they maintain primary control of their creative process. Now, with these principles in mind, I'm going to take you through one of the first decisions of the Copyright Office regarding the copyrightability of images created with the assistance of generative AI. There aren't any court decisions on this question yet, so this is what we have to go on at the moment. So the artist Chris Castanova created a graphic novel, Zaya of the Dawn, that included images she generated using Midjourney. The Copyright Office originally agreed to register the novel, but then they threatened to reverse their decision because they discovered through, I think, media attention that the images were AI generated. They asked her to provide details of her creative process to show sufficient human involvement. She argued that she was the author because of the process she used and that Midjourney was just an assisting instrument, similar to the camera and Cerrone. So Castanova, I guess the difference with Castanova and the images we saw earlier is each image she created was not the result of a single prompt. Rather, she painstakingly shaped each set of prompts over hundreds of iterations to create as perfect a rendition of her vision as possible. So she made very intentional choices as to the visual structure of the images, the selection of poses and points of view, the juxtaposition of visual elements, and she said that this was similar to how a photographer would make decisions. As an example of her process, she discussed this particular image in some detail, which she considered one of the most important in her work. So this image was the result of an extensive iterative process involving hundreds of different versions. The final image includes multiple elements from different generations of intermediate images, all brought together into a cohesive whole by her selection, arrangement, compositing, and extensive use of prompts. She also explained her use of hundreds of detailed descriptive prompts with this image. She paired the prompts you see on the screen with an intermediate image she'd created to produce the final work. So the Copyright Office found that the novel as a whole was copyrightable, and they said that the text in the book itself, the collection and arrangement of the text and images, is protectable. They also said that manual edits that are made to AI-generated images might be protectable if they were sufficiently creative, but they didn't have enough evidence of that here. They found, however, that the AI-generated images were not copyrightable and excluded them from the registration. So Castanova, they said, did not have sufficient creative control over the images created with the assistance of Midjourney, so she wasn't their author. Now, you might have thought, based on the language in Cerrone, that the Copyright Office might have looked at Castanova's level of involvement in the creative process and found it was sufficient. However, instead, the Copyright Office honed in on a different element of authorship that is not present in the case law, which is predictability. And what they said was, because you can't predict precisely what a generative AI tool will produce, there's too much distance between the user and the output of the tool for the user to be considered the mastermind of the process. So that's true no matter how similar the output may end up being to the user's creative vision. So after this decision, the Copyright Office put out a registration guidance on works containing AI-generated material. It mostly reiterates language contained in the Compendium of US Copyright Office Practices, which is the Copyright Office's manual for how they consider registrations. Quoting that, they state in a nutshell, to qualify as a work of authorship, the work must be created by a human and must not be produced by a machine or mere mechanical process that operates randomly or automatically without creative input or intervention from a human, and similar to their unpredictability language in Castanova. In line with this, they also stated that works generated solely in response to user prompts lack human authorship because users do not exercise ultimate creative control over such output. They consider it's the machine and not the human user who determines what that output is. They left open the possibility that some AI-generated works might be copyrightable, but it's very hard to see how based on the tests that they've stated. Following this guidance, they launched an initiative to examine copyright law and AI policy. Those quotes from the tech companies earlier came as part of that, the listening tour they went on as part of that process. And they say they're going to issue a report later this year and an updated compendium to deal with this issue. So keep an eye out for that, because it's possible they'll change how they're dealing with this, but it's also possible they won't. So is predictability the correct standard here? In my view, the predictability standard seems to focus incorrectly on just the output of the tool and not the artist's creative input into the generative AI process. For example, there are many examples of copyrightable works where the artist or creator didn't fully predict the outcome as they were engaging in the creative process, and this unpredictability doesn't thwart authorship. So the wind might blow a subject's hair or leaves in a photograph, or cameras might capture something that a photographer didn't notice at the time, but these works can obviously be copyrighted. Jackson Pollock couldn't predict how the paint he used would drip onto the canvas, but this also is clearly a copyrightable work. So what would be a more promising theory of authorship? What level of human involvement is needed to constitute sufficient human authorship for creative works produced with generative AI tools? And how can we best determine who has ultimate creative control in these situations? So before the advent of generative AI, courts have undertaken similar inquiries in the context of software and the output of software, and they articulated a possible framework that I think would be helpful. So these decisions suggest a different way of framing the authorship inquiry, and they suggest that the entity, whether that's the creator of the program or the user of the program, that supplies the lion's share of the creativity to produce the output should be awarded copyright in the output. So I'm going to briefly look at one case that shows how this test might work in practice. So this decision, Tarasoft and Drosnin, is from 2001 from the Southern District of New York. Michael Drosnin is an author who wrote this book called The Bible Code, about a hidden code said to be contained in the Hebrew Bible containing prophecies, so complex that only a computer program could decipher them. Drosnin used software owned by Tarasoft that was developed to decipher this code, and he included printouts of matrices produced from that software in his book. So on screen you'll see an example of a matrix that was in his book. So how this was produced: he input the words Albert Einstein into the software. The software rearranged the text of the Hebrew Bible into this matrix, which then reveals the prophecy you see on the screen. They prophesied a brainy person. So, yeah. So Tarasoft sued Drosnin for copyright infringement, claiming that he infringed its copyright in the software by reproducing the matrices in his book. Drosnin argued that he was the author of the matrices since he created that output using his particular queries from which the software created the matrices. The court disagreed with Drosnin, finding his creative role marginal, but the language the court used is important. So I'm going to read that out. So creating a matrix is unlike the creative process used in many computer art programs, which permit an end user to create an original work of art in an electronic medium. It is fair to say that users of such programs often supply the lion's share of the creativity to create the screen display. By contrast, the end user of the Tarasoft software merely inputs a word or phrase which the software searches for in the database. Thus, the Tarasoft software does the lion's share of the work. Beyond that, Drosnin's inputs, which were generally no more than a word or phrase, failed the minimum threshold of originality, and for both those reasons, he was not found to be the author of the matrices. So while Drosnin's actions were insufficient to constitute human authorship in that case, the way the court framed and described the lion's share balancing test suggests it would be a better method for determining whether the human authorship requirement is satisfied in generative AI cases. I think most generative AI-generated content probably wouldn't be copyrightable still, even with this test. The actions of users is likely to be marginal in most cases, similar to Drosnin's inputting of a search query. However, work such as Kashtanovas might fall over the line. Her creative choices seemed far from marginal, more akin to the use of the computer art programs described in Drosnin. and could be said to constitute the lion's share of what was reflected in the final images. So what does this have to do with the copyrightability of font software in the United States? So you may have heard there's been some changes in how the Copyright Office has been dealing with registrations for font software, or perhaps seen online discussions that may have started questioning whether font software remains copyrightable in the United States. These center largely on the question of the level of human involvement font designers have when using font editing tools. I don't have a lot of time to go into detail here, but I would argue that the lion's share test is also the most helpful way of framing copyrightability and authorship of font software, as it keeps the focus on the creative choices made by font designers when designing font software, and your ultimate creative control over the result, regardless of the font editing tools that you use. So font designers are the masterminds. You have primary control of the creative process. You contribute the lion's share of the creativity when designing font software using font editing tools. I would also say I think it's incumbent upon us as an industry to publicly and forcefully make arguments such as these about why font software is copyrightable in the United States. Because if we don't do it ourselves, we certainly can't expect defendants in licensing disputes to do so. So a few final takeaways. Some legal considerations if you do start using generative AI tools in your workflow. So as you've seen, even if you have highly detailed involvement in the process, that may not be sufficient to make the output copyrightable under US law. The legal test is still to be determined, but you need to pay attention to this if you do have US clients. If you're filing a copyright registration in the United States, you must explicitly disclaim any AI-generated material. If you sufficiently modify AI-generated content or use it in a compilation, that might be enough. However, in either case, it's going to be critically important to keep contemporaneous records that distinguish all human and AI contributions in your workflow and clearly document changes you've made to AI-generated material. I think it's important also to pay close attention to the terms of service of any generative AI products that you use. They might say, for instance, that the output is owned by the user. However, you need to remember that ownership doesn't mean it's going to be protectable under copyright law. Does the generative AI tool require a license back to use your outputs for further training? Or does it authorize third parties to create derivatives? And finally, and I think this is most important, you need to be careful with any IP reps and warranties in your agreements, whether you're licensing fonts or perhaps assigning rights to clients, because you might not have a copyrightable interest that you can transfer. Thank you.
That was wonderful. Thank you. If people have questions for Christine, we're out of time for this slot, so you'll have to catch her afterwards, but I'm sure she'd be delighted to talk with you.
Yeah, I would. I tried to cut that down a little more, but it was difficult. So yes, happy to chat afterwards.